All rise.
Kosovo Specialist Chambers is now in session. Please be seated.
Good afternoon, everyone, and welcome inside and outside the courtroom. Before we start and proceed to my decision setting the date for this initial appearance, the photographers are permitted to take a few photos for 1.5 minutes. And before you start, I will ask you not to make any picture of Mr. Thaci next to the security guards, please. You can proceed. Thank you. Thank you very much. You may now leave the courtroom. Mr. Court Officer, could you please call the case?
Good afternoon, Your Honours. This is case number KSC BC 2020-06. The Specialist Prosecutor versus Hashim Thaci, Kadri Vaseli, Rajab Salimi, and Yakub Krasnici.
Thank you very much, Mr. Court Officer. Before asking those present in the courtroom to introduce themselves, I would like to remind again a few rules that must be observed at all times in order to make courtroom proceedings smooth. Please make sure you activate your microphone before speaking and you switch it off as soon as you finish. Talk slowly and clearly as we have interpretation in Albanian and Serbian. Wait 5 seconds before responding to me or to a party or participant in order to allow the interpreters to finish the interpretation. What is said in this hearing is transcribed in real time and will be reflected in a transcript available to the parties and to the public after this hearing. I would also like to remind the parties that certain information in this case is subject to protective measures and confidentiality orders. This includes confidential information that has been redacted from the confirmed indictment as to the identity of certain individuals, dates, locations, and other information. I also remind everyone that confidential information shall not be disclosed in open session. If any party or participant must go into private session and refer to any confidential information, please indicate the reasons. Now, I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Thank you, Your Honor, and good afternoon. The Specialist Prosecutor's Office is represented today by the Specialist Prosecutor Jack Smith, Deputy Specialist Prosecutor Alex Whiting, Head of the Legal Advisory Section Claire Lawson, Prosecutor David Harbach, and I am Senior Prosecutor Alan Teeger.
Thank you very much. Now I turn to the defense, please.
Good afternoon, Your Honour. My name is David Hooper. I'm a member of the Bar of England and Wales, and I have the honour of appearing on behalf of Hashim Thaci this afternoon. And I'm insisted today by Miss Sophie Menegon of the Paris Bar. Several of my colleagues are unable to be here for reasons that I dare say we all know. I'll name them. There's Counsel Mr. Pierre Prosper, who I believe is in San Francisco, Mr. Dastid Palaska, Kosovan lawyer in Pristina, Mr. John Greenblatt, who's in Washington, D.C., and a number of others, of those who assist, who are also in Pristina. And may I say at the outset, it's unfortunate, if I may say so, that this process has been put in place without notice to the defense, without adequate notice to the defense. I'm sure the prosecution knew and understood not only our interest to be given notice, but also, I'm pretty sure, our clear intention to cooperate with the court, as Mr. Thaci has done throughout the several years, pre and during the constituting of this court. It could have been better done. After all, these offences reach back 22 years. The court's been investigating these matters for 10 years and 5 years, and you yourself have had the indictment, I think, for 6 months. So essentially, the first that we knew about these matters coming to fruition, if I can put it like that, was, I think, late on Wednesday night, that we got notice of that. So it's not been possible to either establish a team, a defense team. It's not been possible to have people here who would wish to be here. And for our part, we're at a loss to understand why it was necessary to have an institution like this act in such a precipitate manner. And I'll come to address that a little more in due course. Now, Your Honour has, I know, a list to get through, and I'll sit down and enable Your Honour to conform to those duties. Thank you.
Thank you very much, Counsel. Now, I also want to mention that Mr. Thaci is also present in the courtroom for the record. I turn to the registrar. Madam Registrar, please.
Good afternoon, Your Honour. Fidel O'Donnell, Registrar.
Thank you, Madam Registrar. And for the record, I'm Nicholas Guillou, pretrial judge for this case. The accused is appearing today for the first time before the specialist chambers, following the indictment confirmed against him. Mr. Thaci, would you please rise? Full name.
Hashim Haji Thaci.
And date of birth.
A Kosovan citizen born on 24th of April 1968.
You may be seated. Let me now move to the procedural history of the case. On 26 October 2020, in my capacity as pretrial judge, I confirmed the indictment submitted by the specialist prosecutor against the accused, charging him with 6 counts of crimes against humanity, namely persecution, imprisonment, other inhuman acts, torture, murder, and enforced disappearance of persons, and charging him with 4 counts of war crimes, namely arbitrary detention, cruel treatment, torture, and murder. The accused was arrested in Kosovo on November 5th, 2020, and he was transferred to the detention facilities of the specialist chambers in The Hague on the same day. Mr. Thaci, before we proceed any further, I have to make sure that you can follow the proceedings in a language that you can understand and speak. Can you confirm that you understand and speak Albanian?
Yes.
By this, I am satisfied that you can follow the proceedings in Albanian, a language that you can understand and speak in accordance with Rule 92 of the Rules of Procedure and Evidence. If at any moment in the course of the proceedings you are not receiving interpretation, please draw my attention to it immediately. Now, allow me to explain the specific purpose of the initial appearance for the benefit of the accused and those joining us in the public gallery and following the proceedings online. Today's hearing is not a trial. No evidence will be presented or debated, and the guilt or innocence of the accused will not be discussed or decided. The purpose of this initial appearance is regulated by Article 39 of the law and Rule 92. According to these provisions, as pretrial judge, I shall have the charges in the confirmed indictment read to the accused in a language he understands and speaks. Confirm that the accused understands the indictment. Satisfy myself that the rights of the accused, in particular his right to counsel, are respected. Inform the accused that within 30 days of today's hearing, he will be called upon to admit guilt or plead not guilty on each charge set out in the indictment. If the accused wishes to do so, he may immediately admit guilt or plead not guilty. And finally, I shall also set other dates as appropriate in performing my functions as pretrial judge. I expect the parties to adhere to these matters, which I will address in turn. Should either party wish to discuss any other matter not expressly foreseen in the context of the initial appearance, they are invited to do so in writing by making a filing before me. First, may I ask you, Mr. Thaci, to confirm that you have received the confirmed indictment dated 4 November 2020 in a language that you understand and speak?
Yes.
Thank you, Mr. Thaci. I will now ask Mr. Court Officer to read out the charges in the confirmed indictment as foreseen in Article 39 of the law and Rule 92. Mr. Court Officer.
In the confirmed indictment, the specialist prosecutor charges Mr. Hashim Thaci with Count 1, the crime against humanity or persecution punishable under Article 13(1)(h) of the law. Count 2, the crime against humanity of imprisonment punishable under Article 13(1)(e) of the law. Count 3, the war crime of arbitrary detention punishable under Article 14(1)(c) of the law. Count 4, the crime against humanity of other inhumane acts punishable under Article 13(1)(j) of the law. Count 5, the war crime of cruel treatment punishable under Article 14(1)(c)(i) of the law. Count 6, the crime against humanity of torture punishable under Article 13(1)(f) of the law. Count 7, the war crime of torture punishable under Article 14(1)(c)(i) of the law. Count 8, the crime against humanity of murder, punishable under Article 13, 1A of the law. Count 9, the war crime of murder, punishable under Article 14, 1C of the law. And count 10, the crime against humanity of enforced disappearance of persons, punishable under Article 13, 1 of the law. These crimes were committed between approximately April 1998 and August 1999 at a number of locations in Kosovo and northern Albania, including Bare, Bagore, Lapatish, Majak, Potok, and other locations in Podojove municipality, Drenok, and other locations in Rahovac municipality, Berisha Mountains, Lapushnik, and other locations in Drenas municipality, Ferizaj and other locations in Ferizaj municipality, Giljan in Giljan municipality, Jablanica in Jakovo municipality, locations in Kačanik municipality, and other locations in Lipjan municipality, Likoch, and other locations in Skenderaj municipality, Malishev and other locations in Malishev municipality, Voljake in Kleine municipality, Novo Berde in Novo Berde municipality, Zalash and other locations in Pristina municipality, Prizren and other locations in Prizren municipality, Suareka and other locations in Suareka municipality, and locations in Viti municipality, and Kahan and Kukesh in northern Albania. These crimes under counts 1, 2, 4, 6, 8, and 10 were committed as part of a widespread or systematic attack directed against the civilian population in Kosovo and northern Albania from at least March 1998 through September 1999. In particular, these crimes targeted opponents who were perceived to have been collaborating or associating with the Federal Republic of Yugoslavia, FRY forces, officials or state institutions, or otherwise not supporting the aims or means of the Kosovo Liberation Army, KLA, and later the Provisional Government of Kosovo, including persons associated with the Democratic League of Kosovo, and persons of Serb, Roma, and other ethnicities. These crimes under counts 3, 5, 7, and 9 were committed against persons not taking active part in the hostilities and in the context of and associated with a non-international armed conflict in Kosovo between the KLA and forces of the FRY and the Republic of Serbia, including units of the Yugoslav Army, police, and other units of the Ministry of Internal Affairs and other groups fighting on behalf of the FRY and Serbia from at least March 1998 to approximately 16th September 1999. In relation to these crimes, there is a well-grounded suspicion that Mr. Thaci is criminally responsible pursuant to Article 16(1)(a) of the law for a. committing as a member of the joint criminal enterprise the crimes under counts 1 to 10, or alternatively, committing as a member of the aforementioned joint criminal enterprise the crimes under count 1 to 10 by being aware that such crimes might be perpetrated in carrying out the common purpose of the joint criminal enterprise, and by willingly taking that risk, and or aiding and abetting the crimes under counts 1 to 10. In addition, and in the alternative, there is well-grounded suspicion that Mr. Thaci is criminally responsible pursuant to Article 16(1)(c) of the law as his superior for the crimes under counts 1 to 10.
Thank you very much, Mr. Court Officer. Mr. Thaci, I wish to remind you that this is not the time to contest the charges, but simply to acknowledge that you understand the charges. You will have ample opportunity to challenge the charges with the assistance of your counsels. Mr. Thaci, do you understand the charges contained in the confirmed indictment as read out to you by Mr. Court Officer?
Yes, I understood them. I heard them today, I read them, and I do not agree with any of them.
Thank you, Mr. Thaci. Now, let me inform you of your rights before this court. The law on the specialist chambers and the rules of procedure and evidence guarantee you a number of rights. I will read out the most important ones. First, you shall be presumed innocent until proven guilty beyond reasonable doubt. In the determination of the charges against you, you are entitled to a fair and public hearing, subject to any measures ordered for the protection of victims and witnesses. You have the right to be informed promptly and in detail, in a language which you understand, of the nature and the cause of the charges against you. You have the right to have adequate time and facilities for the preparation of your defense and to communicate with the counsels of your own choosing. You have the right to be tried within a reasonable period of time. You have the right to be tried in your presence and to defend yourself through your counsel. You have the right to have counsel assigned to you and without payment if you do not have sufficient means to pay for it. You have the right to examine or have examined the witnesses against you and obtain the attendance and examination of witnesses on your behalf. You have the right to have the free assistance of an interpreter if you cannot understand or speak the language used in court. You have the right not to be compelled to testify against yourself or to admit guilt. You have the right to remain silent, and no adverse inference shall be drawn from your silence. You also have the right to make unsworn statements relevant to the case, and you may appear as a witness under oath. You have the right to lodge preliminary motions to challenge the jurisdiction of the specialist chambers, to allege defects in the form of the indictment, and to seek the severance of indictment. You have the right to receive, within 30 days of today's hearing, the supporting material to the indictment submitted for confirmation. You have the right to receive all statements of witnesses whom the specialist prosecutor intends to call to testify at trial in the language you understand and speak, namely Albanian. You have the right to receive immediately any information which may reasonably suggest your innocence or mitigate your guilt or affect the credibility or reliability of the specialist prosecutor's evidence as soon as the information is in his custody control, or actual knowledge. You have the right that all material and relevant evidence or facts in possession of the specialist prosecutor be made available to you before the beginning and during proceedings. This right is only subject to restrictions which are strictly necessary and when any counterbalancing protections are applied. You have the right not to be detained for an unreasonable period prior to the opening of the case, to request review of decisions on your detention, and to appeal such decisions directly before the Court of Appeal. You have the right to appeal directly before the Court of Appeal a decision on preliminary motions challenging the jurisdiction of the specialist chambers. And you have the right to seek leave to appeal other decisions. Mr. Thaci, you heard the most important rights you enjoy in accordance with the applicable legal framework of the specialist chambers. Do you understand these rights?
Yes.
Thank you, Mr. Thaci. I wish to inform you that according to Article 21(5) of the law, you may not represent yourself because you are currently in detention. Representation by specialist counsel is therefore mandatory. It is my duty as pretrial judge to ensure that your right to counsel is respected. To this end, I have noted the registrar's filing informing me of the appointment of counsel, and I also took note of what your counsel mentioned at the beginning of this hearing. Counsel, can you just confirm that you have been appointed to represent Mr. Thaci?
Yes, I confirm. Thank you.
Thank you very much, Mr. Hopper. I am therefore satisfied that the accused is presently represented by counsel. I will now turn to the possibility for the accused to enter a plea, if any, in accordance with Rule 92. Mr. Thaci, within 30 days from today, you will be called upon to admit guilt or to plead not guilty on each charge in the confirmed indictment. If you wish to do so, you may also choose to immediately admit guilt or plead not guilty. I would therefore like to ask you if you have had the opportunity to discuss the charges in the confirmed indictment with your counsel, and if you are prepared to enter a plea at this time. If it is the case, I invite you to stand up while you plead.
Your Honor, the indictment is completely without basis, and I plead not guilty.
I just ask you to confirm that you plead non-guilty for all the counts in the indictment.
I reiterate, the indictment is completely without basis, and I plead not guilty to all the charges in the indictment.
Thank you very much, Mr. Thaci. Now, let me move to the working language of the proceedings. In the scheduling order for this initial appearance, I asked the parties to make submissions on the working language to be used in the present case, according to Rule 8. Mr. Prosecutor, I know you already mentioned your submission this morning, but if you can please reiterate for the benefit of the accused present. Thank you.
Yes, thank you, Your Honor. Our position is that the working language for these proceedings should be English.
Thank you, Mr. Prosecutor. Counsel.
Be little surprised that we have little objection to that. As far as Mr. Thaci is concerned, he has English, he can speak English, some English, but he would need to be assisted in the way that he is currently with Albanian translation. Thank you.
Absolutely.
And similarly with documents, of course, yes.
Duly noted. I will issue an order in due course on this matter. As indicated in the order for this initial appearance, I will schedule a status conference, pursuant to Rule 96, to be held shortly after the initial appearances of all the accused. The purpose will be to review the status of the case and to organize exchanges between the parties to ensure expeditious preparation for trial. Mr. Thaci, I wish to remind you that you have the right to attend the status conference with your counsel. However, with your written consent and after receiving advice from your counsel, pursuant to Rule 96.2, the status conference may be attended by you in person with your counsel participating via video conference link, by your counsel with you, Mr. Thaci, participating via video conference link, and it may also take place in your absence, Mr. Thaci, with your counsel present or participating via video conference link. I will now ask the parties for their views on a suitable date for the status conference to be held on or after Wednesday, 18 November. And for the defense, would it be also possible to indicate whether you plan to participate in person or via video conference, and which lawyer, if possible, would participate? This is mainly so that we can organize the video conference with the different lawyers in this case. But first, Mr. Prosecutor.
As indicated earlier, Your Honor, the prosecution is available at the court's convenience, and the suggested date is suitable.
Thank you, Mr. Prosecutor. Mr. Hooper.
On behalf of the defence, and it would be principally me as lead counsel who would be hoping to attend any and all hearings, unlike the prosecution, we are necessarily at a geographical and COVID-ridden disadvantage. And given the arrangements that need to be put in place, the requirement for certain parties to obtain visas, for example, in order to attend, an interest party, not necessarily just counsel, we had asked for the 30th of November. I think that's a Monday. It was a date I looked at earlier, but I think it was the 30th of November. But may I come back in a moment, if Your Honour would be gracious enough to allow me to have the floor again, in order to perhaps put that into better context in terms of what we'd be seeking from Your Honour over the next several weeks. Thank you.
You will receive a scheduling order that will include the agenda in due course. I just want to mention that given our legal framework, we are a bit constrained by some deadlines, especially deadlines for disclosure to you. This is why it seems quite difficult to have such a delay before the first status conference. But we will try to accommodate as much as we can and as much as it's possible for the disclosure process. As I mentioned this morning, I will ask the SPO in the order scheduling the status conference for written submission by Friday, November 13th, and I will also probably then ask the defense for their observation in reply in the following days. And after the status conference, I will issue a decision on the specialist prosecutor's disclosure obligation in accordance with Rule 102 and on the redaction regime for the proceedings. And this is an important step for the defense because this is what will allow you to get all the evidentiary material. At this point, I would like to ask the parties whether they have any other issues they would like to raise. And I remind the parties to give prior notice should any submission require the disclosure of confidential information so that appropriate measures may be taken. Mr. Prosecutor.
There is nothing further from the prosecution, Your Honor.
Counsel, you have the floor.
Well, I'm grateful for Your Honour inviting me to address you on other matters within the confines, of course, of what is appropriate at this stage, necessarily so. Your Honour has had, or been labouring, as it were, with the draft indictment for some 6 months, and this is the first opportunity that Your Honour has had, in fact, to hear any matters or submissions from the defence. Now, Mr. Thaci has pleaded not guilty, of course, as we've all heard, to each and every allegation on this indictment. And I wish to make it plain that he disputes the entire narrative of this indictment as presented by the prosecution. Of course, we were aware, because the prosecution announced back in June that it laid an indictment before Your Honour, an unusual and perhaps wrongful step, but they announced it, and to that extent we were on notice that that process was in hand. And we now have the indictment, albeit that it's still greatly redacted, and so perhaps isn't as informative and instructive to the defence as it would be if the censorship was lifted. But looking at that indictment, the defence posed this question: where are the allegations of organ theft? After all, and the Yellow House, that was the allegation that was the raison d'etre of this court.
Sorry, I think Mr. Thaci has a problem with interpretation.
Translation wrong. So, wrong, is it? Well, I'll carry on. May I carry on? I'll address that perhaps in due course. So I don't know. I haven't. The language is wrong. All right. Well, first, the translation is.
Is it, Mr. Thaci, so that I can understand, is it a technical problem?
No, it's in language.
All right.
It's
All right.
substance.
Well, I tell you what I'll try and do to address that as best I can. I will speak.
It's in substance, not technical. Mistake.
Thank you.
Very well. Well, to the interpreters, first of all, we all understand the. Right. So maybe we need. Well, there's little I can do about that, or doubtless Your Honour this afternoon, except I can speak more slowly, and I will do so. So let me just repeat the part that I was reaching here for the interpreters. And I was raising this question that, and it's an important question, and one I know that people in Kosovo will be very attentive to. And the question was this: where are these allegations of organ theft? Because they were so significant in terms of the birth of this court. And
again, it's wrong. Sorry.
all right.
It's not fair. Again, it's the translation.
All right. Yeah. Let me continue. All right.
Mr.
Yes,
Thaci,
we'll address it in due course. Let me carry on. And if I'm speaking too quickly for the interpreters, please let me know, and I will do my best to slow down. But I think I normally speak at a sufficiently slow pace. So where are the, third time, where are the allegations of the theft of human organs and the story of the Yellow House that featured so prominently in the incentive to create this court, following, as we all know, the dramatic half-page in Carlo Del Ponte's book, which was then followed by the Dick Marty report, and which, in those allegations, apart from being a most dreadful stain on Kosovo and Kosovans, was, of course, the allegation that propelled the setting up of this court, this Kosovo court. I say Kosovo court, but looking around, I see nothing of Kosovo in it, may I say. There's no emblem here from Kosovo. I don't know why not. It's a very barren place here. Perhaps some attention could be paid to that. If this is a Kosovo court, let us have the black eagle on the red. Let's see it.
Then you should wear a red gown, Councillor.
Well, I'm not a member of the Kosovo bar. I'm an independent member of another bar, and I think that's important to bring in our costume into the court. I'm not in the position of Your Honour, or perhaps my learned friends, for the prosecution, dressed attractively as they are. So there we are. Now, those allegations, Mr. Thaci knew was nonsense. And because he knew it was nonsense, he assisted the European Commission in the setting up of this court. And we hear that he's may not have been cooperative, but you can't be more cooperative than being a midwife at the birth of a court such as this. And so he was. But there we are. Nothing in this indictment speaks of the theft of organ and those terrible, terrible crimes that were alleged. Instead, it seems, we have a collection of incidents in the indictment of offences and events, many of which have been tried at both the International Criminal Tribunal for Yugoslavia or Kosovo courts and Kosovo-based courts, all wrapped up, as it were, and strung together, had placed on top of it a structure of command. Well, those allegations will, through the trial process, be shown, I hope, to be false. They will be fought vigorously and, I anticipate, successfully. Now, we were, as I think I've perhaps indicated, surprised that it was thought necessary to order Mr. Thaci's arrest rather than proceed by summons. And that was done, presumably, following submissions made to you by the prosecution. We don't have those submissions. It had been my intention to seek to make an application for his immediate interim release this afternoon. I think I gave the court some little notice of that on Saturday. But it would be, on reflection, we feel, inappropriate to make that application this afternoon without knowing what it is that the prosecution are specifically alleging, both by way of risk to flight. Well, risk to flight, he's here. He's flown here. So I think we could strike that particular suggestion out. But presumably you were told that he was a risk. Well, there we are. But the second limb of it, which deals with interference, I don't know the allegations that support that conclusion of interference. And we need to know that on an audi partem principle, let alone the practicalities of such an application. We need to know what is in fact being said. And I'd ask Your Honour that, in fact, we be provided with those specific elements of information, separate, distinct, as it were, from supporting material, that the prosecution put forward in their arguments before the 26th, up to the 26th of October, so that we can see what those are. And I'd also be requesting that an application for interim release be made in the next few weeks, once we have that information, be made before Your Honour, orally, with me in attendance. I know this court, unlike some of the other courts, is moving towards principles of orality, and O-R-A-L-I-T-Y, and that is something which we embrace. It will give me the opportunity to have Mr. Thaci here, you to hear the arguments from the prosecution and also from the defence, and to be fully informed as the independent judge and figure that you are. To address that question, very important question, particularly these days, and that is, does this man really merit being detained here or not? Given that there's also a presumption at this court that liberty is assumed unless certain criteria are fulfilled to justify detention. So, in the meantime, bearing in mind that for 6 months, as it were, you've had the prosecution whispering in your ear, I feel it's appropriate, and not inappropriate, to just say a few words about Hashim Thaci, to Your Honour, who I can present as a man of integrity and honour, a man who has served his country in war and peace, a man who has achieved much and does not merit these allegations. I was provided a book just the other day, so I don't want to speak, as it were, and have these things said from my mouth. I think particularly as the prosecutors appear to be almost uniformly American cousins, I'm going to quote from the foreword of this book by Bob Dole, who, of course, we know was a leading American senator, also a presidential contender, when such contenders were respectable, if I can put it like that. He said this at page 8 of the introduction. It's a short paragraph, and I'll read it. He says, Kosovo has had an incredible journey, and one man critical to the development of this bastion of democracy in the Balkans is President Hashim Thaci. As a young man, barely 30 years old, he headed the Kosovo Albanian delegation at the international conference at Château de Rambouillet in France. Thaci came to the table as an unknown quantity, but by the conclusion of the conference, 2 weeks later, he was recognized as the voice of reason during a time of severe internal factionalism. The fate of the nation rested on Thaci's keen ability to convince his fellow fighters to compromise. Not an easy task for those in the field who were witnessing the atrocities being committed by the Serbian forces. So, there we are, spirit of compromise and of justice, even within a disgraceful attack by Serbia on the Kosovan people. So he, Hashim Thaci, emerged from those talks, from that war, as a voice of reason, from terrible atrocities inflicted on his country by Serbia. And he brought his country against all odds to independence and freedom, and helped shape the country that we have today. That's a country that is young, youthful, vibrant, multicultural, multi-ethnic, tolerant, supportive of all religions, and one where he was seeking, up until last week, to help put away the past, to seek some measure of reconciliation with Serbia. I have another quote, even shorter, much shorter, but it's very apposite, I think. It's at the back of the book. Hashim Thaci is the George Washington of Kosovo. That was Joe Biden, US Vice President, 2009-17, and President-elect today. And I hope Joe is listening. So, I say those words. It's not a hagiography on my part. It's a beginning of a balancing. It won't be your job to search for the truth in this matter. It would be that of a panel of other judges. But there we are. These are all first small steps. But we're sure that by the end of it all, the reputation of this man will be vindicated. I was very surprised, I must say, when I walked through that door there a moment ago to meet him this afternoon, and he's there in handcuffs. Disgraceful. We're not a punitive body, this court, I hope, and I hope something can be done to address that, not to demean a man to that extent. He takes it well. He's that sort of man. Now, Your Honour, I mentioned that for my part, I'd be grateful if we could have an oral hearing on issues relating to interim release. And I'd anticipate, I hope, that given that the information we want is very little, really, I would have thought, in terms of submissions that may have been placed before Your Honour by the prosecution to seek an arrest warrant, that could take place in 2 weeks or so. Your Honour, I'm presently based quite a long way away, and as I say, my commitments are such that a date close to the 30th of November would have, I hope, the advantage to Your Honour of my being here, and certainly the advantage to Mr. Thaci of my being here, together with others. And I hope that colleagues on other defence teams and the prosecution indeed are amenable to a date somewhere like that. And whether that's part of the, or supplementary to the status conference, a day before or whatever, probably better to have it before, would be satisfactory. Indeed, perhaps that particular application doesn't need to be before the status conference, it can be afterwards. Your Honour, I'm very grateful to you and to my friends, actually, for listening with some patience through those submissions. Thank you very much.
Thank you very much, Mr. Hooper. I think there is one very important point is what you mentioned, is that you need to have access to a lot of evidence and proceedings. This is why we need to have a robust and fast disclosure process so that you can have access to the filings that have been indeed made before the arrest of your client. And this will be made as soon as possible. I guess the prosecution might want to respond. So, Mr.
I do on a few matters, Your Honor, if I may. First of all, most directly to the matter you just raised. While it is our position that by virtue of the provision of the arrest warrant, the defense is in position to address the matters that gave rise to the arrest warrant, it has been our intention, nevertheless, to provide an appropriately redacted version of the application for the warrant at the earliest opportunity. We're working on that now. We expect to be able to provide that by the end of the week. We look forward to responding in detail to any written submissions regarding the basis for detention, the factors that need to be considered by the court in identifying and assessing the risk to the integrity of the proceedings, to the security of victims, witnesses, and others. And we will be addressing that in detail from matters that are traditionally incorporated into such assessments, such as the nature and gravity of the charges, the availability of resources and networks to facilitate flight or interference, leading up to such matters that shed light on the possible risk of interference or flight, including very recent events such as the fact of Mr. Thaci's, on the very day the arrest process began and he was informed, of pardoning two people convicted for the murder of an alleged collaborator back in 2001, and who were convicted in 2012 and finally apprehended after they had been fugitives for some period of time. Those matters will be addressed in detail, and appropriately so, in the course of the written pleadings and any oral submissions that may follow. I think it is instructive that after reading in full an indictment which contains the accounts of dozens and dozens of murders and the plights of hundreds of victims, what we hear about is what Mr. Thaci is not charged with. Each and every one of the charges and the events that are contained in the indictment are squarely within the mandate of this tribunal. And that's what we should be talking about and what we will be talking about during the course of this trial. Finally, with respect to the testimonials offered by the defense, were any of those people here in court now, I would say to them, as we do under other circumstances, sir, at the time you made that statement, were you aware of the evidence from dozens and dozens of people, from the family members of deceased victims, about the responsibility of the person about whom you're speaking? And that is also what we will address during the course of this trial. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Counsel, do you wish to say anything?
Merely this. In terms of an application for interim release, given the nature of the laws that make detention an exception, I'd submit it's appropriate for the prosecution to let me have, and let Your Honour have, as it may have done already, but for my benefit as well, their arguments to which we can respond. Thank you.
Thank you very much. And I just wish to address one point that you mentioned, Mr. Hooper, regarding the handcuff. There is no specific treatment for your client. This is the proceedings that we apply to any person who is under the custody of the specialist chambers. But I will just give the floor to Madam Registrar for a second so that she can supplement, if she wishes, on the practice of this institution in that matter. Madam Registrar.
Thank you very much, Your Honour. Just to emphasise, as the pretrial judge has, that the normal procedure for escort to the courtroom does involve the use of handcuffs, which are removed prior to entry into the courtroom. So there was no exception in the procedure today. Thank you.
Thank you, Madam Registrar.
Would you want to just give me one moment? I think Mr. Thaci wanted to say a word to me. Thank you, Honour. It was essentially reflections really on what my learned friend said about these two men who were, as he put it, pardoned. There's more of a history to that, but I think I can address Your Honour on that, I hope, at the next opportunity I have before Your Honour, rather than take it forward today. Thank you.
Thank you, Counsel. Mr. Prosecutor?
Thank you, Your Honor. I may have initially misunderstood the final submission of the defense. If counsel was suggesting that he wanted to have more information about the initial submissions that led to the current detention, we already addressed that. If, on the other hand, he was suggesting that we change the customary order of proof, that is, he wishes to alter the current state of detention, but wants to have the prosecution go forward initially, of course we would oppose that. That would be contrary to the jurisprudence of all of the ad hoc institutions and the logic behind the application generally.
Thank you, Mr. Prosecutor. Mr. Hooper?
Well, offhand, I don't know any jurisdictions where it's up to the individual to submit that he should be free, as opposed to the state or prosecuting authority making application that he should not be. And you'll bear in mind that your order under which presently Mr. Thaci is detained, the arrest warrant was issued in the light of submissions, as I understand it, made to you by the prosecution. Audi partem. We haven't had knowledge of those, and you haven't heard us on it. And I'm saying that, in fact, it would be fair for us to hear the prosecution's position so that we can react and make our submissions appropriately to you, rather than for us to have to say, quite contrary to the spirit of the laws, we don't fulfill the criteria. It's for them to show that he does fulfill the criteria. And it's for that reason that we should, I think, proceed in that matter. It wouldn't prevent them, for example, as starting parties from making a reply to our submissions. But I think it just gets the carriages of that train in the right order. That's the submission. Thank you.
I don't know if the court needs to hear from us further, or maybe this is a matter for written submissions, Your Honor, but the reality of the situation is the prosecution did make submissions, the court made a decision, the defense now wishes to have a change in that condition. We would expect it to go forward. We understand that counsel has asked for the information upon which those earlier for the information of those earlier submissions. And again, for the second time, I reiterate that we anticipate providing that shortly. So perhaps there's a little bit of talking in circles. He will have that information. He will be then file his pleading, and we will respond.
Thank you, Mr. Prosecutor. I think we've heard the parties on this matter, and we'll wait for the submissions on this issue. Mr. Thaci, I would like to ask you if you have anything to say regarding your arrest, transfer, and detention in The Hague.
Jessica Schadot, thanks.
Well, everything I wish to say is something that was set out by my defense counsel. I have nothing else to add.
Thank you very much, Mr. Thaci. Finally, I inform you that I will issue a decision ordering the specialist prosecutor and the registrar to reclassify their filings or prepare redacted versions, as the case may be, so that the defense has access to them as soon as possible. As you remain in detention, Mr. Thaci, I would also like to inform you that you may challenge your detention on remand in accordance with Rule 57, and this will be dealt, as you, Counsel, mentioned, in the following weeks. Unless the parties have anything else to say, this concludes today's hearing. I thank the parties, the registry for their attendance. I also wish to thank the interpreters, stenographer, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned. Thank you.
All rise.